I've received a few questions from some of my YouTube subscribers about important, interesting topic, and that is, can a judge overrule a jury in Canada? Great topic, interesting question. I'm going to break that down for you today. So let's say a person has elected to be tried by judge and jury. What does that effectively mean, first of all? Well, it means this. Number one, the jury they're going to be the decision makers on the facts about whether you're guilty or not guilty. That's primary, first and foremost. So we call that the jury or the finders of facts. The judge is in charge of the law. So the judge is in charge of, during the jury trial, controlling what evidence goes in, what's legally right and not right, and then giving the law to the jury in their throughout the trial, and at the end in the judge's address to the jury, telling them, rehearsing or reviewing the facts of the case and telling them what the law is and their possible verdicts. So what happens then? Can the judge overrule the jury at any point in time? Well, first of all, the basic answer, with exceptions, is no. But I'll tell you this: if the jury renders a verdict of not guilty, the trial judge has no ability to overturn that verdict by themselves. First of all, okay, that's the jury's purview. Can the judge also tell the jury to convict? No, the answer there is no as well. The judge can review the law, they can review the facts. Now, they can tell the jury what they think of the facts, they can hint at their opinion or even provide their opinion, but they have to say, it's up to you. Look at this credibility of this witness, though I thought they weren't the best. It's up to you, and it's up to you whether reasonable doubt. Like, a lot of judges will stay neutral, but are judges allowed to give their subtle opinion to the jury? Yes, but they can't direct them to convict. In rare circumstances, they can direct an acquittal, though. If the Crown has, say, finished its case, and the judge determines at law and based on the facts that there's no evidence upon which a jury properly convicted could convict. In other words, the Crown has not proved an essential element. There's no chance any jury is going to convict. The judge can direct an acquittal in that point. So they're taking it away from the jury, essentially, and directing an acquittal, telling the jury to quit. The judge directs it, essentially. Okay, so that's one minor exception, if I might put it that way. Other situations, sometimes there's a mistrial. So, for example, you're not really overruling a jury, but let's say 12 jurors can't decide. Let's say it's 11-1 and they're deadlocked after 2 days. What's going to happen in that situation? Well, they're going to come and tell the judge, look, we can't reach a decision. Now, the judge in that situation may exhort the jury, look, try your best. I want you to go back in the room, do your best to come to a decision. So that's called an exhortation. The jury comes back in a couple hours, says to the judge, we still can't reach a decision. Well, the judge might not give an exhortation if he or she feels that the jury's exhausted. There's no chance. The jury said there's no chance. The judge is going to direct a mistrial, so he's taken it away. So that trial ends, and the Crown has to decide whether to do a new trial or not. Sometimes in Canada, on lesser charges like a sexual assault, typically the Crown's not going to try 3 times after 2 mistrials. Sometimes murders, I've seen 3 trials, but typically you're not going to get multiple kicks of the can on mistrials, but that's kind of a general rule of thumb. It's not always followed. So there you have it in terms of where the judge can take it away from the jury on mistrials. Another way mistrials happen, if something really unfair happened, like some prejudicial evidence went into the trial, the defense said something wrong, or the Crown introduced some wrong evidence, or there was a tainted juror who found out is friends with the victim, for example, the judge can declare a mistrial at any time, even after a verdict. If they find out tainting of the jury, that's a possibility too. But the general rule of thumb is this: like, the judge is in charge of the law, the jury's in charge of the outcome. So a judge can't overturn by himself, the trial judge who's sitting as the trial judge, the jury verdict. They can't direct an acquittal, so they can't overrule a jury there. They do tell the jury what the law is, but the jury is in charge of the facts. Now, another subtle answer to this question is there are rights of appeal, though. That's not up to the trial judge, though. It's up to the defense counsel. Like, if defense is convicted, the defense has to decide then whether to refer this to appeal court, which is a higher court. For example, if it's tried the Superior Court of Justice in Ontario, the appeal court is the Ontario Court of Appeal. And you're going to appeal if there's errors of fact or law, substantial miscarriage of justice. So a guilty verdict might possibly be overturned if the Ontario Court of Appeal finds major errors, the substantial miscarriage of justice that contributed to a wrong finding, for example. It's rare to substitute a verdict, frankly, but you could possibly get extremely rare, if not impossible, on a jury case. But not completely impossible, but what happens a lot are new trials are ordered and you get another kick at the can as you're the accused. Or the Crown is allowed to appeal, not errors of fact, if the jury is allowed to make an error of fact, but the Crown can appeal on errors of law. For example, if the judge didn't direct the jury properly on the law, or there was improper rulings on major issues leading to substantial miscarriage of justice. So all in all, the bottom line is, here's the general rule of thumb. A judge cannot overrule a jury in Ontario generally, with these rare exceptions that I talked about, but that's typical. The jury is in charge of finding guilt or not guilty. The judge can't interfere with those decisions except in the rarest of circumstances, what I talked about. But we do have appeal rights both for the Crown and defense in circumstances where the Crown and defense feel there's appeal grounds. So there you have it. It's an interesting topic. The right to a jury trial is a very important right, both in Canada and the States and throughout certain democratic countries. And certainly I recommend a lot of my clients do jury trials on serious matters over the years. And so that's the takeaway, that, once you're in the hands of the jury, the judge has little say, if any, except in the exceptions about what's going to happen to your ultimate verdict, other than your appeal right as an accused. Thank you for joining me today. If you enjoyed this video, I encourage you to subscribe, and we look forward to seeing you on the next video. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.